We have Mr.
We have
Mr. Duchesne.
Yes, Mr. Duchesne is present.
Duchesne, if you can come up to the podium, please. All right, Ms. McCree, if you could unmute, and are you able to hear me okay?
Yes, I am. Good morning.
All right, good morning. You're appearing on People versus Sean Duchesne, is that correct?
That's correct.
All right, we'll go on the record. This is People versus Sean Duchesne, case number 246723. The record should reflect that Ms. McCree is here present by video by prior approval on behalf of the state. Mr. Trush, you're here on behalf of Mr. Duchesne.
Yes, Your Honor.
Mr. Duchesne is present in the courtroom this morning. Mr. Trush, can you tell me the status of this file today?
Yes, Your Honor. So we're still in a little bit of a pickle on this one. This is a case we have an offer from the Attorney General that we intend to take advantage of. The Attorney General wanted, I think, about $5,000 or so paid down on the arrearages before he could take advantage of that offer. We're working our way to that place. Just to remind the court a little bit of background, Mr. Duchesne was lodged until I think about the end of July. July 10th. Since he's got out, he's been making consistent payments, actually making a pretty substantial amount of payments in that time period. We're still not quite to the point that the Attorney General wants us to be. And I would indicate, he showed me, he made an $1,800 payment today. I reached out to Mr. Ahuda Coker to talk to him to see if we could maybe modify that offer given the recent progress, but I was not able to get in touch with him by the end of last week. So that's kind of where we're at. As I see it, there's really a couple different options the court could take at this point. And I'm assuming that Ms. McCree probably does not have the authority to change the offer. If I'm wrong, correct me.
Wouldn't have the ability to do that because I don't have the same payment history that you reflect. The last payment that I have was $300 on September 13th, and then $300 on July 25th, and that's as of 10/17. So obviously, if there was a payment made today, I don't see that reflected in the notes that I have, but I don't have that there had been any payments since the last time the parties were in court. So without that information, I wouldn't have any ability to adjust.
So I think that leaves the position of the court could operate in one of a few different manners. I understand this case is getting a little old. The court could docket a trial with a final pretrial conference. I expect that we'd be at the final pretrial taking advantage of the offer, or the court could give us one more adjournment for maybe 60 days. I expect with the payments that we have and expect to have in that time period that we'd be in a position to take advantage of it.
Okay. All right. Well, I mean, based on the age of the case, it was found over in the middle of May, so that's been 5 months. I think the court needs to get this docketed for trial so that we have a resolution date, final resolution date out there. I anticipate that would be at least 90 days out, so and perhaps longer. Pardon me. So that would still give the parties an opportunity to continue to work towards resolution. Ms. McCree, do you have any objection to that?
I don't have any objection. I do have a question about bond because I haven't seen that if there was a bond paid on this particular case, a cash bond, that it's been assigned over to the front of the court. I know the different counties do it differently, but I was just wondering if there was cash bond paid, and if so, if there can be an agreement to assign that over to try to reduce the arrearage, because unfortunately his arrearage has gone up. He's up to $26,761.62, and he does have a $177 current monthly obligation. So I was hoping if that bond had been paid, that could help to reduce his arrearage if it's signed over to FOC.
So we would have no objection to that. I think the bond was fairly minimal in this case. He's reporting to me that what he posted was about $500.
Okay.
But I also recognize, I mean, every little bit helps.
Yeah, I mean, Mr. McCree, I think from a procedural standpoint, I don't think the court would be able to apply that bond until the case is resolved, but certainly at that time, the court you know, would, it sounds like there would be no objection to that, so certainly we would, that would occur.
So I'm not to interject, but I mean, we have in the past done stipulations to apply the bond to it, which would, I think, effectively by stipulation, turn it into a personal recognizance bond.
Right.
We're open to that. I guess what I would suggest is I will reach out to the Attorney General. As long as we can have an agreement on it, I think, again, every little bit helps.
Yeah, if there's a stipulation, I have no objection to it either. So I'm assuming if this were to go to trial, it'd be a 1-day trial, Ms. McCree?
Correct, Your Honor.
So I'll set it for at least 90 days out for a 1-day jury trial. And the court will set this for a plea hearing at 60 days and final status conference. Mr. Trush, anything else we can address for your side today?
No, Your Honor.
Ms. McCree, anything further from your side?
Nothing further, Your Honor.
Okay. Mr. DeShane, do you have any questions?
I didn't get the paperwork for court today, so I think that maybe my address is wrong with the court. I have moved around a lot over the past couple of years. I know I could probably call downstairs and not take up the court's time, but is my address on there 746 Idaho Avenue?
No.
Okay, I'll change it.
Yeah, if you just want to go right downstairs right after the hearing, that would be a good idea.
Yeah, I wouldn't have known I had court if my attorney didn't reach out to me. I would have missed it.
Okay, so then definitely make sure that you stop downstairs since we've confirmed that we do not have the right address now. Okay, all right, thank you.
Thank you.
Your Honor, I believe that's the only case that I have on your docket for today. May I be excused?
Yes, thank you.
Thank you.
Lost my mouse here.
Your battery. What size batteries, Jeff? Double A. I'll be right back.
What's on the battery?
Sometimes I'll do that too, while you're waiting for the battery.
Suggestion, thank you. Guess that's the same thing, they turn it off, turn it back on. All right, there at the jail, sir, can you tell me your name, please?
The second?
Yep, at the jail, Mark James, is that James, sir?
Yes.
Yes, okay. Mr. Rolla, are you able to hear me?
Yes, Your Honor, can you hear me?
Yep, okay, we're on the record now in People versus Brian James, case number 226265. The record should reflect that Mr. James is present by video from Otsego County Jail. If I could have counsel put your appearances on.
Thank you, Your Honor, for the record. Michael on behalf of the people.
Thank you, Your Honor. Richard Trush appearing on behalf of Mr. James.
All right, this hearing was set. Mr. James, I believe, was arrested last week on a bench warrant that has been outstanding for quite some time. Back about a year, a little over a year. So the court, based on that bench warrant, revoked Mr. James' bond and remanded him to custody and set today for a status conference and bond hearing. Mr. Trush, have you had an opportunity to speak with Mr. James?
I have, and I do want to just supplement the court's recitation of the history. I actually think that Mr. James was arrested not last week, but the week before.
Okay.
He reported to me when I spoke to him last week that he'd been in since the prior Friday. For whatever reason, I don't think the booking information got out when he was booked in. I only found out that he was in the jail because his significant other contacted me. I went over there and talked to him. I asked the court to docket a hearing so we could potentially address bond. So I would indicate I did go over, I talked to Mr. James. The factual circumstances have changed somewhat in terms of us potentially taking an offer or not. I don't know that we're in a position to do that, but some things have changed in his circumstances that I think clear things up for us a little bit. Most directly, though, I would like to ask the court to consider a bond here today. Mr. James obviously was not present and not picked up for a significant amount of time on this. He reported to me that at the time of the missed hearing, his father had passed away. That sort of was the domino that set off and triggered a bunch of events that were pretty difficult for him to deal with, including obviously losing his father, losing his home that had served as his grandfather's home, his father's home, and his home. And then subsequent to that, as he started to get back on his feet, he got arrested on the warrant, I think technically out of Oakland County, but being supervised for Genesee County. From there, he came here. So I think that's kind of the full procedural background of things. I would ask the court to consider, I think the initial bond set was 10,000 cash or surety. I would suggest to the court setting it at 25,000 cash or surety would be an appropriate amount. That'd be more than doubling up the prior bond to assure that he does in fact appear and take care of it. And then I would indicate, at least from my perspective, I had good communication with Mr. James up until those events. And again, from what he indicated to me, it was pretty catastrophic. He basically lost everything. So that would be our request today.
In terms of going forward, do you want the court to docket this for trial?
So I would ask the court for one more status conference. As I said, there are some things that have changed that I think make a plea more likely. So most notably, at the time of the offense, I think he was on parole. His parole has been closed out and he's no longer on parole, which effectively kind of removes the consecutive sentencing concern. And again, I think that increases the probability that we're going to be able to come to a resolution on it.
All right, thank you. Mr. Rolla, first, as to the scheduling, do you have any objection to the court setting this for an additional status conference / plea hearing prior to setting it for trial?
No, Judge, and if the court could repeat the case number, please.
This is file number 226265.
Okay, thank you. That's what I thought. I just want to make sure I had the right one. As to the issue of bond, Your Honor?
Yes.
Again, it's unfortunate that Mr. James lost his father. Obviously, no one wants to have that happen. I know I had that experience back in last December. That being said, however, that's a long time ago, and he has been no contact with the court. Apparently, Mr. James isn't back before the court until he's arrested in another county. So I do believe that a significant cash bond will be necessary for the defendant to be required to appear. Otherwise, we can set it for a plea hearing, but the people have little faith in the defendant appearing unless he has another incentive to do so, because the plea offer was out there. He was off probation and off parole for some time now, yet he didn't come before the court, didn't contact his attorney. Thank you, Your Honor.
All right, so in terms of scheduling, the court will set this for an additional status conference plea hearing in about 30 days. In terms of bond, Mr. James, the court has to consider a number of different factors. The seriousness of the underlying charges. You're charged with 2 5-year felonies as a habitual fourth offender, which makes those life offenses. One of those is fleeing and eluding third degree, and the other felony, one of the other felonies includes carrying a concealed weapon. So the court has concerns not only about the seriousness of the underlying offenses and the potential maximum possible penalties, but also the nature of those offenses. Obviously, your failure to appear in court back in 2023 or at any time since then to take care of this also gives the court concerns regarding your appearance before the court at a future date. All that being said, I do think you are entitled to a bond. I don't think the court has grounds to deny bond. However, I do think a high bond is necessary both for public safety and to ensure your appearance going forward. The court will set bond in the amount of $50,000 cash or surety. And then again, we'll set this for another hearing in about 30 days. Mr. James, do you have any questions?
No, thank you. You guys answered all my questions. Thank you.
All right, Mr. Trush, anything further today?
Mr. James, just make sure before you leave the jail, you take a copy of my card, okay?
Okay, will you be able to come down to see me? My only concern is I've been charged with these same exact charges in another county, but I never had any court dates or any type of hearing or anything. And my bond has been revoked in that county as well. I don't know how to go about that. My apologies if I'm stepping over my boundaries asking that in this court case.
So, Mr. James, I will come over and talk to you once I finish up my docket today. I only have one more case. So probably in the next less than a half hour, I would guess.
Okay, thank you. That answers all of my questions. Respects to the court, and my apologies for disrespecting the courts.
All right, thank you. That's all for this hearing today.
And judgment,
Thank
the
you.
court commission, I'll be leaving shortly and coming on my way to court because we have the bonding matter that's supposed to be in person.
Yeah, we're ready for that right now. So why don't you just stay right where you're at?
That's fine, Judge. I'll be happy to do that. I just want to do that with the court's permission.
Yeah, thank you.
Free to go, Your Honor. Back to
Yes. Yep, we're all set. Thank you.
Okay.
Go on the record in People versus Bonamy, case number 216097. The record should reflect Mr. Bonamy is present here in the courtroom today. If I could have counsel make your appearances on.
Thank you, Your Honor. For the record, Michael, on behalf of the people.
Thank you, Your Honor. Richard Trush, appearing on behalf of Mr. Bonamy. Your Honor, I would indicate I've had some communications with Ms. Davis from the probation department, and I think we do have a resolution of this for the court today.
Okay.
Specifically, Mr. Bonamy would be making admissions to the request for violation that's dated on 9/9/2024. That's a 3-count request, all of which being violations of term 3. So again, the specific allegations on or about 8/15 of 2024 were failed to report as instructed. 8/22 failed to report as instructed, and 9/5 failed to report for a scheduled violation hearing. He would be admitting to those 3. The remainder of the violations would be dismissed. And I believe that Ms. Davis is going to be recommending unsuccessful discharge with credit for the time that he served in jail.
Right, Ms. Davis.
Yes, and just to wrap that up, there are 6 bench warrants. So in exchange for pleading guilty to that bench warrant, we dismiss all the other ones that are pending. He was extended for 9 months down in district court for a domestic violence charge that he has there. And he is also going to court for Alpena domestic violence as well. He's entitled to 133 days jail. I was going to ask to discharge him unsuccessfully. His case has been since 2021, but he's been on probation. And then fines and costs, any that he continues to owe would remain preserved, Your Honor.
All right, Mr. Bonamy, have you had a chance to talk to Mr. Trush about entering into this plea today?
Yes, sir.
Is that how you wanted to proceed?
Yes, Your Honor.
You raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help me God.
Yes, sir.
Mr. Bonamy, you understand that you do have the right to have a hearing as to whether or not you violated your probation?
I understand that. Yes, sir.
You understand that by pleading guilty, you're going to be giving up that right?
Yes, sir.
Okay. Also, although we've heard what the recommendation is with regard to sentence, and I don't object to that, you understand that the maximum penalty you could face for violating your probation is that on your underlying charge, which is delivery of a controlled substance, which is 7 years. You understand that?
Yes, sir.
Okay. With all of that in mind, what is your plea to the alleged probation violations today?
Guilty, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we said here in court today?
Other than time served, that's what I was,
Anything outside of that?
no,
Okay. Is it your own free choice to enter into this plea today?
yes,
Are you pleading guilty because you did violate your probation?
yes,
Back on August 15th of this year, were you on probation here in Otsego County?
yes,
Were you aware that one of the conditions of your probation at term 3 was that you were to report as instructed by your agent?
yes, Your Honor.
Did you fail to do that on that date?
Yes, I did. It was my father's birthday and he just passed away. I went to his memorial instead.
Did you also fail to report to your agent on August 22nd of 2024?
Yes, I did.
And then again on September 5th of 2024?
Yes, sir, I did.
The court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there's a factual basis to support a finding that you did violate your probation as alleged. The court will accept the guilty plea. In terms of sentencing, Ms. Davis, anything other than what you've already had to say?
No, Your Honor.
Mr. Roll, anything you wanted to add on behalf of the people?
No, Your Honor, thank you.
Mr. Church?
Just very briefly, what's been outlined by the probation department here, I think makes perfect sense. Mr. Bonamy has some unique medical issues that pose some problems for him. He's spent a lot of time in and out of various hospitals. Those pose problems for him in terms of reporting, obviously. In addition to that, he has a substantial amount of credit, has been on probation for a significant amount of time already. And with the two other layers of supervision, meaning the district court probation, as well as the charge apparently in Alpena, I think that the recommendation makes sense.
Mr. Bonamy, anything that you wanted to say?
No, thank you, Your Honor.
All right, I'm very familiar with this case. You had a number of proceedings in the court during the time that you've been on probation. I don't see any further benefit either to you or to the community by keeping you on probation here in this court as part of this case. And so the court agrees that the recommendation is appropriate. The court is going to sentence you to 133 days in the Otsego County Jail with credit for 133 days served. The court will preserve any outstanding fines, costs, and discharge you unsuccessfully from probation in this case. You do have the ability to seek an appeal of the sentence, and we're going to provide you with some papers that explain what your appellate rights are.
We can, if you just 1 second.
Yeah, so Mr. Bonamy, we'll get those to you in just a second. If you just want to have a seat for a minute, please.
Go back to the phone.
Our next hearing is set for 10 o'clock, and so we'll be in recess until that time.
And that's gonna be in person, correct, Judge?
Yes,
All right, I'll see you then before 10 o'clock. Thank you.
thank you. We're on the record in People versus Cole, case number 246749. The record should reflect Mr. Cole is present here in the courtroom today. I'd like to have counsel put your appearances on.
Morning, Your Honor, for the record, Michael on behalf of the people.
Good morning, Your Honor. John Steffi on behalf of Mr. Cole. We're both present here before you today.
Mr. Steffi, how did you want to proceed today?
Thank you, Judge. We are here to enter a plea. We submitted that agreement to the court. Our plea agreement, excuse me, subject to your approval, would be a plea of guilty to count 2, which is a resisting or obstructing Officer Waters. Count 4, an operating while intoxicated first offense. And an added count 5, which is possession of controlled substance, cocaine, less than 25 grams.
That's a 4-year.
Yes.
Okay. Mr. Rolla, is that a correct statement of the plea offer?
Yes, Judge.
Mr. Cole, have you had an adequate opportunity to speak with your attorney about this plea agreement?
Yes, sir.
And what we've said here on the record today is that your understanding of what the plea agreement is? What we've said here on the record today is that your understanding of what the plea agreement is?
Yes, sir.
Is that how you wanted to proceed today?
Yes, sir.
Could you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. Mr. Cole, are you currently on any kind of probation or parole?
No, sir.
Right, and you understand that the maximum possible penalty you could face for resisting or obstructing a police officer is up to 2 years and or a $2,000 fine?
Yes, sir.
And the maximum penalty that you could face for possession of a controlled substance less than 25 grams is up to 4 years?
Yes, sir.
And that the charge of operating while intoxicated as a first offense is a misdemeanor punishable by a maximum of up to 93 days in jail and or a $500 fine. Do you understand that?
Yes, sir.
With all of those maximum possible penalties in mind, what is your plea to each of those charges today?
Can I have a moment to speak with my attorney?
Absolutely. Mr. Cole, did you need more time to speak with Mr. Steffi, or are you okay to proceed?
I'm okay to proceed.
So I'm going to go through your rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. Do you understand all of those rights?
Yes, sir.
You understand that you're giving up and waiving all of those rights by pleading guilty?
Yes, sir.
Also, oh, okay.
And you come back on when you start giving.
Okay, great, thank you. So the clerk is just pointing out that I had asked you a question before you wanted to speak with Mr. Steffi, and that was what your plea was to each of the charges today. And so can you tell me what your plea is to each of the charges?
It'll be guilty.
Okay. So back to the discussion of your rights. Again, you understood all those rights that I read to you.
Yes, sir.
And you understood that you're waiving those and giving those up. Also, you don't have an automatic right to appeal the plea that you're making here today. If you want to try to appeal it or get your plea reversed, you would have to ask the next higher court up, which is the Court of Appeals, to hear your case. If they said no, then you wouldn't be able to go any further with that appeal. Do you understand that?
Yes, sir.
Has anyone threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anyone promised you anything other than what we said here in court today?
No, Your Honor.
Is it your own free choice to enter this plea?
Yes, Your Honor.
Are you pleading guilty because you are guilty of each of these charges?
Yes, Your Honor.
The date that I have for this incident is back on April 19th of this year. Is that the correct date?
Correct.
On that date, had you been consuming alcohol?
Yes, sir.
And after you consumed alcohol on that day, did you operate a vehicle here on Highway M32 here in Otsego County?
Yes, sir.
Did you have any blood or breath tests done to determine the level of alcohol in your system at that time?
Yes, sir.
Do you remember what the result was?
Judge, if I may, it was a 0.168 via blood test.
Mr. Cole, do you have any reason to doubt the accuracy of that test?
No, Your Honor.
As part of that incident, did you also have possession of some cocaine?
Yes, sir.
Did you know that that's what that substance was?
Yeah, yes, sir.
Did you have any legal right to have that at that time?
No, Your Honor.
Did you also come into contact with an officer from the Gaylord City Police Department?
Which is in contact. Did they pull me over?
Yeah.
Yes.
Oh, sure. And I don't know if you know that officer's name, Officer Waters. Does that sound familiar?
Correct, Your Honor.
Okay. And was he wearing his police department uniform at the time? Did you know that he was there performing his duties as a police officer?
Yes, Your Honor.
Did he give you some commands or order you to do something that you failed to do? Or, Mr. Steffi, maybe you can answer.
Yes, Judge, thanks. Benoist, after you were arrested, officers, including Officer Waters, took you to the hospital for a blood test, is that correct?
Correct.
And when you were at the hospital and they were trying to secure you for the blood test, you were resisting their efforts to do so, correct?
Correct.
And they gave you lawful orders because they had a search warrant to get your blood and you did not comply with that, correct?
Correct.
Thank you. Thanks.
Mr. Are the people satisfied with the factual basis as to each charge?
Yes, Your Honor, thank you.
Mr. Steffi?
I am, Judge, thank you.
Mr. Rolla, are the people aware of any threats, promises, or inducements other than what's been placed on record?
No, Your Honor.
Mr. Steffi?
None.
And Mr. Rolla, are the people satisfied that the court has complied with statute or the taking of this plea?
Yes, Your Honor.
Mr. Steffi?
I am satisfied, thank you.
Mr. Cole, the court finds that your plea is knowing, voluntary, accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of each of these charges. The court will accept your guilty plea as to each. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. It's important that you stay in touch with Mr. Steffi prior to that time. Also, before you leave court today, you're going to meet with Ms. Davis from the probation department. She's going to set up the time with you for a pre-sentence interview. Mr. Steffi, anything further you need to address today?
Nothing, Judge, thanks.
Mr. Rolla?
Nothing further, thank you, Your Honor.
All right, thank you. That's all for today.
Have a good day.
That's great. Pretty funny. I'll get you a case under the.
Yeah.
Commission.
Yep, thank you.
Next hearing is a friend of the court hearing. It's set for 10:15. I'm just waiting for the jail to connect on that. Ms. Delane, I'm just waiting for the jail to connect with Mr. Foost. Sure.
Ready to do this first case number.
All right, sir, are you Nicholas Boost?
Yes, Your Honor.
Okay, we'll go on the record, and this is Hornstra versus Boost. This is case number 2218992. The record should reflect Mr. Boost is appearing today by video from Otsego County Jail. We also have Ms. Blaine here present on behalf of friend of the court. Just for the record, Mr. Foose, there was a bench warrant that was issued for your arrest back on September 4th for your failure to appear at a hearing. Mr. Foose was arrested on that bench warrant last week, at which time the court was made aware that there was still 15 days remaining on a prior sentence that had been held in abeyance. So in light of the failure to appear, the court ordered that Mr. Foose serve those 15 days, which is why he's currently lodged with Otsego County Jail. And then the court set this for basically a status conference hearing. Ms. Blaine, is the friend of the court seeking additional findings of contempt, or how does the friend of the court want to proceed today?
Your Honor, we are seeking contempt due to the defendant continuing to fail to appear for hearings and for his failure to pay from available resources. He's had 3 jobs that we're aware of in 2024, totaling $6,882.85. He's only paid $161.70 on his docket during that time, and also had a conversation with his caseworker on June 17th, indicating he was working 7 days a week. However, the June payment was only $37.59. This would be his second or subsequent finding of contempt, as he was previously found in contempt on September 7th of 2023.
All right, Mr. Foose, so the friend of the court is requesting that the court find that you're in contempt. Because this would be a second or subsequent finding, the maximum penalty that you could face would be up to 90 days in jail. Do you understand that?
Yes, Your Honor.
Okay. You've heard Ms. Blaine indicate or state in terms of what your work history has been and your payment history. Is there anything about what she said that's incorrect from your standpoint?
With what I've been going through with my jobs, every job I do get arrested at my job site. I do get fired. Every job I get within 2 weeks of working there. And then I gotta fill out applications, which puts me in this situation where my last job, I got arrested down in East Tawas and I got sent to Kalkaska for 45 days. That's why I missed my last court appearance for September 3rd. The jail knew I had a court. I let them know I had court, and I told them I had time, what time it was, what day and everything, and I didn't even show because they didn't put me in the Zoom. I called the county clerk, said that I was incarcerated. I sent proof of verification of incarcerations. I've called when I got out, and I was told that there's nothing that can happen. And I've been looking for a job since I've been out of Kalkaska County Jail. On September 5th, I think it was, is when I got released from that jail. I haven't had a job since I got arrested for Kalkaska's jail. I've been looking, filling out applications. Reason why I moved out of Gaylord to go to East Tawas. Because I got nothing here in Gaylord. No company will hire me. No place will hire me. And that's what I've been dealing with ever since. Every job I get arrested at the job site and I lose the job. And then 2-3 months later, filling out applications, I get another job. I get arrested for failure to pay child support, which isn't under me because it's coming out of my paychecks. I got pay stubs that said only $130 has been taken out. It leaves me with like $50, $60 in my account, in my pocket.
how am I supposed to make a living for myself? How am I supposed to eat? How am I supposed to pay my own bills? When I can only get $50 to $80 in my pocket after working 2 weeks. All my money goes to Kalkaska first because my child support there is almost $900 a month. I can't make a living. I can't survive with Kalkaska's 900 and then this county is 120 something a month. That's almost $1,000 a month. I don't make $1,000 a month. I got tickets that I gotta pay. I can't pay those tickets because all my money goes to the child support. That's why Sheboygan, I was up in Sheboygan. That's why Chippewa has a bench warrant on me. Because I don't have money to pay those tickets.
Have you filed a motion with Kalkaska to try and get your child support reduced?
Yes, I filled one out while I was in the jail. Back in June. Well, July.
Okay,
and
what's this?
I have no
status?
word on it.
What's the status of that?
I don't know, truthfully, because I haven't got a letter in the mail saying a court date. I haven't got anything. I filled it out and then I got released out of the jail. So I was in Wexford County for 45 days.
Have you done anything to follow up on it to see where it's at?
But I've been incarcerated.
That's
I'm
not
in
my
and out of
question.
jail, so I don't get to use my phone to get a
Have you
hold of
done anything?
anyone.
Have you done anything to follow up on it?
No, because I've been inside the jails, so I can't get a hold of them. Sheboygan wouldn't let me call them. East Tawas wouldn't let me call them. Right now, I'm fighting 2 cases in East Tawas that randomly popped up on me. And they're 2 felony cases that they want to send me to prison for the rest of my life. And I'm here. I'm not there fighting them. I don't want to go to prison for the rest of my life, but with me not being able to hold a job, with me not being able to pay my rent for my house, I lost my house 4 times this year because of child support payments. I mean, I'm at the point where I'm about to just say, screw it, and just accept the 2 felonies and accept the 4th habitual and just end it all. Because I can't make a living. I can't stay at my house. I lost my dog because of this. I'm just losing myself. I can't hold a job, all of that. And I wrote a letter to Kalkaska and Otsego County in front of the court from inside of Wexford County, asking for 6 months or so I can get my life together. I've been on the street for the past 5 years, living under overpasses, homeless. For the past 5 years.
Okay, how many children do you have?
2.
How old are they?
I got my daughter who's 3 and my son who's 5.
Okay, so while you've been living in under overpasses, you've still been having children, right?
This was before. I had the children before I was homeless.
You said you've been living under overpasses for the past 5 years.
Well, with the exception that I was living with my ex-wife, Haley, in Kalkaska for a few months. And then we had our daughter and then we broke up, got a divorce. And then since then, I've been in and out of jails, living on the streets.
All right. All right. Well, it sounds like most of that's been your own doing. That sounds like you've gotten yourself into trouble in a lot of different places. And in the meantime, while you've been undergoing these hardships because of your own problems, your children have been going out without any support as well. So not only, I guess, are you losing your dog and all of your stuff because of your criminal entanglements, but your children are also going out without support. So I don't have a lot of sympathy for you in that regard. The fact is that you haven't been paying support. You haven't done anything that I can see from the file here in this county, which is what I'm dealing with, because I really don't know what's happening in Kalkaska County. You haven't done anything to make payments or to work with a friend of the court on other options if you can't make payments. You basically just have ignored it. And that's not acceptable. If you can't make payments because of your situation, then you need to take other actions. And there are plenty of options. And the friend of the court, I can tell you right now, will work with you to try to find other options short of putting you in jail, because that doesn't do anybody any good. But if you're not going to make payments and you're not going to work with the friend of the court, you're not really leaving the court with any other options. So the court is going to order that you serve the remainder of your 15-day sentence as set forth in my prior order. And then the court is going to order that you serve 30 days in the Otsego County Jail. On this contempt, the court will hold the remaining 60 days in abeyance. You can purge that sentence with a payment of $1,360 at any time. Otherwise, you'll be released after that 30 days. Once you're released, the court will order that you contact the friend of the court immediately upon release. Ms. Blaine, I'll ask that you prepare an order reflecting that ruling to the court today and submit that to the court for signing. And that's all I have for today. All parties are free to disconnect on this file.
Thank you, Your Honor.
Must be a thing.
Morning, Judge.
Hi, good morning. Trying to see, I don't see Mr. Sisson connected, but we do have Dean Nelson. Do you know if that's a lawyer from the same firm?
I don't, Judge. I don't. I'm not familiar. I'm trying to look. What's the name of the firm?
I don't know. Unfortunately, I don't have a lot of information.
Neither do I. Well, why don't we give it a shot? See if it is the right person. You wanna?
Have you spoken with Mr. Sisson at all?
We haven't in a while because the case was dismissed because of an administrative situation, and then it's reinstated. And so it has been honestly a couple months.
Okay.
And that was just briefly emails. I'm familiar with the name. Trying to see.
Okay. Mr. Nelson, are you appearing on the Flat versus Boeing USA case?
I am not. I'm here for the 11:15 corn matter.
Okay, got it. Thank you. I'm gonna put you back in the waiting room for now.
I'm happy to just do a simple scheduling if you'd like, Judge, and pass on the information. It's not a complicated case. It's a premise slip and fall for Boyne Mountain or Boyne Highlands.
Okay. Let me just try one more thing here.
Excuse me.
Mr. Smith, are you appearing on the Flat versus Boeing USA case? I'll take that as a no. Okay, so let's go on the record then. This is Flat versus Boeing USA, case number, Emmett County, case number 24108-330-NO. I'm presiding over this matter by assignment from SCAO. This was set for a pretrial scheduling conference today. It was set for a hearing at 11 a.m. It's now 11:08. Mr. Sisson has not appeared. We do have Mr. Deegan present by Zoom video. And so we're going to conduct some scheduling today. To the extent that Mr. Sisson has objections, we can address those at a later date. But Mr. Deegan, can you just tell me what you would like to see going forward then?
Yeah, as I indicated, this is a slip and fall at Boyne Highlands. I'd like your typical 180 days of discovery. And I think for witnesses and exhibit lists, we could probably name those in 45 days.
Okay.
I do think it's a case appropriate for mediation. I'll suggest Matt Coffey, who I've had good luck with, but maybe if we could have 2 weeks to figure one out, but I'll get with Mr. Sisson about that.
Okay.
Thinking about other things, I anticipated this positive motion possibility, and maybe I don't know how you like to schedule those after discovery, or I'll look to the court for guidance, but I anticipate the potential of a dispositive motion.
Okay.
I think that about covers it. Pleadings are fine, but I would say 14 days to amend is okay by me too.
Okay. All right, so we'll say 6 months for discovery. I'll put in the exchange of witness and exhibit list as you indicated. The pretrial order does give 14 days for the parties to attempt to agree on a mediation to occur just within that 6 month period, whenever the parties feel it'd be most appropriate. I will set it for a dispositive motion 30 days following the close of discovery. And then I'll also set it for another status conference by Zoom at about that same period. So if there are no motions filed, we'll have a date on the calendar for a status conference. And if not, then we'll proceed with any motions.
Okay.
And 14 days to amend pleadings or add parties. And I think that covers it unless there's anything else you can think of.
That sounds good to me for a Monday, Judge. Yep.
All right, I'll send out an order with all these dates in it, and you are free to disconnect. Thank you.
Yeah, have a good week. Thanks.
Okay, before we get started with the corn matter, Mr. Sisson, I had your matter scheduled at 11. Mr. Deegan did appear. I called the case, I don't know, about 11:08, 11:10. So we set some preliminary dates, but I stated for the record that to the extent you objected to any of those dates, that the court would consider any objections. But I'm going to place those into an order, and I've got an 11:15 that I need to proceed with. But was there anything you wanted to state for the record?
No objections to the dates, Your Honor. I'll get with Mr. Deegan and figure it out. My apologies. My assistant had it at 1 o'clock and then she texted me and said it's at 11. So my apologies.
No problem. Thank you.
Thank you.
All right, so we'll go on the record then in the Charlevoix County matter of the Corn Family Limited Partnership et al. This is Charlevoix County case 03-1723-19-CB. Again, the court's presiding over this matter by assignment from SCAO. This is set as a status conference following up our previous hearing, which was in July. Just so that all counsel is aware, I did receive on September 3rd a judge's copy of a report from Mr. Finling. I don't know if anybody submitted anything else in writing. If they did, I didn't get a judge's copy of it, but we can go through that as we proceed today. I also had a chance to review my notes from the previous hearing in July, although I typically would review a transcript or the video of our prior hearing to kind of make myself more familiar other than what my notes were, but we've recently updated our software, and so I wasn't able to access that July hearing at this time. So I haven't gone through and watched what we discussed last time. I'm going on my notes. So I'm just saying all of that to just give counsel an idea of where I'm at coming in today. In terms of how we want to proceed today, I do want to have everybody put your appearances on. And so we'll start with the receiver, Mr. Finling.
Morning, Your Honor. David Finley, I'm the court-appointed receiver.
Okay, and then counsel on behalf of Shauna Korn.
Good morning, Your Honor. Howard Shear on behalf of Sheldon Korn, Gail Korn, and Shauna Korn.
Thank you. Counsel on behalf of, let's see, Homer McCarty.
Yes, good morning, Your Honor. Kevin Smith appearing on behalf of the Chapter 7 trustee, Homer McClarty, for the estate of Gail Korn.
Okay, and then counsel for Ashley.
Good morning, Your Honor. David Cleavorn appearing on behalf of Ashley Byron, formerly Ashley Korn.
Right, and then counsel for Simon.
Dean Nelson, and I'm representing Basil Simon, Chapter 7 trustee for the bankruptcy estate of Sheldon Korn.
Right, and then do we have anybody here on behalf of Mr. Lenchner? I don't see anyone. No. Okay. All right. I guess I'm not sure where to start. Does counsel have any suggestions of where you all would like to start here today in terms of status, Mr. Finling?
I might be able to help, Your Honor.
Okay,
Since the
great.
last hearing, my accountant has prepared a draft 2008 tax return, which has been circulated to all the parties. One of the main issues of contention was whether or not the payments from the Korn Family Limited Partnership to satisfy the judgment of Larry Lenchner was tax deductible to the partnership. My accountant has reached the conclusion that it is not. That doesn't mean that everybody agrees, but that's my accountant's conclusion. If I were to file a return for 2008, it would be my position that there was no tax deduction for those payments because it was not incurred as a business expense, but rather the repayment of a past liability that was owed by the partners. Each of the attorneys has had an opportunity to communicate with Mr. Mueller. Their accountants have had an opportunity to speak with Mr. Mueller. To the extent they haven't or they want to speak with him more, they're welcome to do so. Some have offered case law and other positions with respect to the deductibility. And Mr. Mueller has been pretty adamant that he will not adopt those positions. So where it stands right now is, in terms of moving forward, the question is the filing of the 2008 tax returns. The other matters have been put on the back burner, so to speak. I think that's been the communication from all of us. And I'll answer any other questions the court may have.
All right, the ultimate determination on that tax return, I'm assuming that's not going to rest with this court, right? I mean, that's something that's going to be hashed out in a different forum.
No, Your Honor. What would happen is I would, because of the circumstances surrounding the past circumstances related to this entity, I would be seeking approval from the court before I would go forward with the filing of the tax returns. There's been a lot of discord among everybody involved. I would certainly brief it. I'm not asking just off the cuff, but I would certainly ask that the court declare that I have the authority and that I should, based on the returns and based on the information provided, file those returns. And the intention of Mr. Mueller, who's my accountant, would be that once the 2008 return is approved or at least concluded among the interested parties, that he would prepare the remainder of the returns through the present. So the relief that I would be seeking from the court at some future date is the filing of that return, or those returns, I should say. The reason I need the court's imprimatur is that there may be objections to the content of those returns and the implications for each of the partners. But this originated out of Mr. Nelson's request that the returns be prepared to conclude these proceedings and to conclude the bankruptcy proceedings, ultimately with the disposition of the partnership. So before anybody can move forward, the filing of the tax returns is the primary obstacle to where we stand now. I hope I represented that appropriately for everybody.
Okay. All right. So the question may come, and of course I'll hear from everybody on this, but Mr. Finling, just addressing what you just stated, the question of whether or not you have the authority or the ability at this time to file those returns may rest with this court, but in terms of an ultimate determination about whether or not the return or the payments that were made were tax deductible, I mean, that's not something that I'll be deciding, is it?
No, Your Honor, whether it's by evidentiary hearing or by motion, whatever it might be, the receiver would prepare motion and report, which provides the evidentiary support as to why my professional has concluded that the return as prepared should be filed. Each of the interested parties would have an opportunity to object to that and say, no, that's not how it should be prepared. We object. We have professionals who say something to the contrary. And then the court would have to evaluate the professional opinions of those involved and make a decision whether or not the receiver is instructed to go forward. I believe that originally I was not required to file the returns. There's disagreement regarding that, but it's not germane to this hearing. What is clear to me is there's a lot of uncertainty as to each party's position, and I want clarity from the court as to the fact that the return as prepared should be filed. Now, I'm not going to ask that the court simply adopt that position out of whole cloth, but to the extent there are conflicting opinions, that the court should have to evaluate those and make a decision as to whether or not I should proceed. The court may say to me, no, Mr. Finling, based on the professional opinions as I have evaluated them, the return should be filed differently. But I'm not comfortable, and this is not an unusual situation in bankruptcy or in state court, where there is conflicting opinions and somehow the court must direct its court officer, me as the receiver, as to how I should proceed. And there's a lot of conflict, as the court has seen in the past, and I think that it's most appropriate for the court to make a decision as to how the return should be filed, unless there's consensus, of course, among all the attorneys.
Okay, so Mr. Finling, in terms of going forward from today, what you would be asking the court to do would be to set some kind of deadline for you to file that motion and set a hearing date to get that taken care of?
I believe so, Your Honor, yes.
Okay, all right, thank you. All right, I'm gonna just go in order of counsel making their appearances. Mr. Shear?
Yeah, I think there kind of been three issues left in the case at the moment. This tax returns, the receiver's fees and expenses, and the overpayment on the judgment. And I agree that the fees and expenses of the receiver and the overpayment have kind of been kicked down the road. And I think everybody's on board with that. This tax return issue is a very big issue. You know, as the court may recall, there have not been KFLP, Corn Family Limited Partnership tax returns filed apparently since 2006. So we're talking about many years of tax returns. And Mr. Finling has retained Kurt Mueller as a CPA to prepare those returns. And there's really going to be two issues that flow from those returns. One is, I think we all expect there to be some sort of penalties because the returns weren't filed on time. And I think the plan for that is that once the returns get filed, and if penalties get assessed, then I think the receiver is going to do his best to try to get those penalties waived. My recollection of the law is that those penalties would be a liability of KFLP at that level. And depending on how that shakes out, there may be issues relating to that liability if it doesn't get waived. And I think we all expect that that liability might be like $10,000 or $11,000 per year for every year the return wasn't filed. So we're looking at what might be like $180,000 issue. The bigger and immediate issue is that once KFLP files the tax return starting with 08, that's going to then lead to the filing of all the subsequent tax returns, 09, 10, 11, you know, all the way up to date. And not only will tax returns get filed, but K1s will get issued to each of the four corns, Ashley and Shauna individually, and apparently to the two bankruptcy trustees as it relates to Sheldon and Gail. And I've had some discussions. It seems like, take it with a grain of salt, it seems like, at least for the individuals, there's going to be amended returns that will have to get filed for the most recent 3 years. And depending on how much, assuming income gets generated on a K1, in relation to the total income for those individuals, they might need to file amended returns for going back 6 years as opposed to 3 years. One of the things we've been waiting to hear is whether or not KFLP on the tax return is going to take a deduction for the payments more than $2 million that have been made on this judgment over the years. And the court may recall that KFLP is a member of 5 LLCs that own apartment complexes, and those complexes have generated a lot of income that's come to KFLP that it's used to pay this couple $1 million on the judgment. If those payments are not deductible, either as ordinary expenses of KFLP or as losses or for some other reason, then it's likely to generate significant income to the four individuals. I have an accounting background. I passed the CPA exam a long time ago, but I'm not a CPA because I never spent 2 years in public accounting. And I'm having great difficulty trying to comprehend how the individuals could end up with huge tax liability with KFLP receiving income, but using all the income to pay these judgments that were required by a judgment of the Charlevoix County Circuit Court to begin with. It just seems impossible to me that that could be the outcome. As Mr. Finling indicated, I was actually the one, I went and did some research, actually found a Sixth Circuit Court of Appeals opinion from 1956 that would support the deductibility of the expense for those payments. But at least thus far, the receiver's accountant is not comfortable putting his name or having Mr. Finling put his name on tax returns that would deduct those, in his words, because they were payments for some sort of fraud-related judgment and didn't think they were deductible. I know that I spoke with Mr. Cleavorn this morning. He represents Ashley, who's in the same position. And I know that they have not yet had their accountant and really start looking at that. So they're going to start focusing on that now. I have spoke with Dean Nelson, the attorney for one of the trustees, and he has, and both trustees have retained John Bull, the same CPA in both bankruptcy cases, who I think is now going to be looking closer at that. Just so the court's aware, this has been a big issue, but we didn't learn about it until recently that that's what Kurt Mueller's position was, and didn't get his explanation until I think within the last week as to why he thought they weren't deductible. And so now everybody's focusing on that. I know that both Dean and Kevin and their clients are of the same view that they'd like them to be deductible, because if they're not deductible, then those tax liabilities apparently become some sort of a liability to the two bankruptcy estates, probably on some sort of priority level. And so everybody would like them to be deductible, but thus far, the receiver's accountant has not come to that conclusion. And I think from some emails that circulated before the status conference, I think everybody was comfortable either pushing the status conference, having a continuation somewhere down the road where we all get more professional opinions and maybe can persuade Mr. Mueller that that is the appropriate thing to do, to deduct those. Or it's the first time I heard in Mr. Finling's presentation this concept of the receiver filing some sort of motion about filing the returns with the court. And I understand the court's skepticism about whether, as a state circuit court, whether that's the right court to decide the ultimate issue on deductibility and how the returns ought to get filed. And I'm not sure of the answer to that. And I'm not sure if there was some sort of nuance with the way Mr. Finling said the motion would be. But ultimately, if some motion about the filing of the tax returns gets filed, probably the only issue, I think, would be this issue of deductibility, which is going to have a huge impact. And maybe we cross that bridge once we see the motion getting filed. I mean, my hope is that we now know Mr. Mueller's position and the rationale behind it. He wrote an email in response to the Sixth Circuit case that I cited, which I think is binding. And his response said something like, well, that's a case from 1956. And that the statute, the IRS, under the Internal Revenue Code statute, is a different statute. But the statute has the exact same language. It's just a different number since some point when they amended the Internal Revenue Code. And that case law is still good case law. I mean, just because it's from 1956 doesn't, when it's the same statute, that seems to be binding to me. But that's where we're at. And I guess I'm certainly okay. And I think all the other attorneys are okay having inform the court of where we're at in that we need some more time on this issue. And I do think it was a good idea for Mr. Finling to inform the court of, you know, here's what's coming down the road and here's where we're at and why the returns haven't gotten filed yet. But it took until now to just get the draft return and get an explanation, you know, from Mr. Mueller about the deductibility issue, which has created angst for everybody else on this Zoom call.
Okay, all right, thank you. Mr. Smith?
I concur with Mr. Scheer. I do believe it's probably wise to kick this down the road a little bit. What I would like to see is for more opinions to come out. I read the case law that Mr. Scheer had provided, and I'm struggling at why it would not be applicable. Mr. Mueller is he's a very good CPA, but he is not a tax accountant. And I think it'd be wise to invest some money in, and maybe Mr. Finling can do this, to hire a tax attorney to get a more formal opinion, because it is a very big issue, one that we have to resolve. Hopefully we can resolve it together. But I think giving us more time to do that would be most appropriate.
Thank you. Mr. Cleaborn?
Yeah, you know, I don't have too much to add. I think the primary concerns my client has expressed to me is just what the court brought up after the receiver finished his report, is just setting a date and deadline to keep this case moving forward, for if there's going to be a motion on authority to file the taxes, or if there's, you know, just some sort of deadline we can get in the order to, you know, as counsel has indicated, maybe seek a legal opinion from a tax attorney as to the deductibility or non-deductibility. You know, from my client's perspective, I think what we've all talked about, we're all in agreement. I just think there's an emphasis that is I'm getting on my end as far as let's keep this moving forward. You know, the April order, I mean, it's been 6 months, and obviously we have some very big and very significant issues to address on the deductibility or not, that we just got, you know, Kurt's opinion or explanation on it within the last week. But I think from our perspective, I think I'd agree with what's been said. I just, you know, ask that we set some reasonable deadlines as far as going forward. But that's all I have to add.
Thank you. Mr. Nelson?
I only have one additional item to add, and that was more of a history of where this came from. And that's in my original response to, I believe, Mr. Scheer's motion, the trustee raised an issue that this receivership estate could not be concluded until the tax returns were filed, period. And if it is a situation where one of the partners' CPA says, you know what, I disagree with Mr. Mueller, and I'm willing to sign my name to that tax return, I don't think it's beyond comprehension that Mr. Finling does not file the returns, but perhaps one of the partners does. And I'm not saying that we are willing to do that. I'm not saying that any of the partners are willing to do that. But that could potentially be an option as well, because currently I believe the prohibition in the receivership order allows only Mr. Finling to do that, but that could be remedied by changing the receivership order or having an order authorizing one of the partners to do it. And again, I'm not advocating for that, but I do believe it is a possibility if there is a disagreement. But I think what it shows is that we just need to have more time and more discussions over the best way to deal with the deductibility of these judgment payments and the potential dispute regarding it.
And just, even though I'm out of order, Judge, I think that concept might make a lot of sense, might be agreeable to everybody. I think if we have some short period of time, maybe not so short, you know, everybody will have an ability to get input from their own professionals. Maybe we can persuade Mr. Mueller of something, or maybe we can come to an agreement that somebody other than the receiver files the returns. It'll still leave us with the issues about liability for not having filed the returns and who's responsible for that if it doesn't get waived and so on. But I think I think we should keep that all avenues open, and that might be the best avenue.
Okay. Mr. Finling, anything you wanted to add based on what all the other counsel had to say?
Thank you, Your Honor. I'm agnostic as to who signs the returns. If Mr. Scher's client wishes to execute the returns, I'm not going to supersede my accountant's advice to me that I should not claiming a deduction for these payments. But if Mr. Scher's client as a partner of KFLP wishes to do so, no opposition from me. What the difficulty is for me to seek an opinion that's contrary to my CPA's opinion seems a little odd. What I would suggest is that the court pick a date 60 to 90 days out, and if Mr. Scher or any of the other partners' interests have evidence that a contrary position should be taken based on a tax opinion from a tax attorney or something else. Otherwise, that would kind of conclude the question of deductibility, but it's putting me in a position of seeking, I'm fine doing it, whatever the court directs me to do. At some point, we have to have conclusion as to the decision of either my accountant or a tax attorney, whatever it may be, and that will conclude the issue. And then from there, either I file the returns or Mr. Scher's client files a return, but we should pick a date for that to occur rather than just another status conference, because there's nothing difficult now about hiring a tax attorney, providing them with Mr. Mueller's information, providing them with a copy of the tax return, and having somebody make a conclusory statement as to what their position is. And picking a date 60 or 90 days out would then put the issue to bed, presumably, or somebody would have to continue to argue that contrary to the tax attorney's opinion and the CPA's attorney's opinion, they're both wrong and we should proceed with deductibility. So in light of the collective desire to move this along, if we're struggling with the question of deductibility, then the one way to conclude that is somebody who is a greater sophistication and skills such as a tax attorney. And I'm certainly open to the collective suggestion as who to employ. But I think that would leave the uncertainty out of it, because we've chosen a date, we're going to get that opinion, and we're going to have to make decisions based on that opinion. I think that would be the most efficacious way, from what I'm hearing from the parties, to move this forward. Thank you, Your Honor.
Okay. All right. So based on what you've all had to say here today, what I'm going to order going forward is basically that we have this set for another status conference at about 90 days out. Number one, although the issue itself, I agree with counsel, the issue itself isn't a new issue. Mr. Mueller's opinion and the deductibility and that kind of debate is a new debate that I don't think the parties had a fully opportunity yet to flesh out. And I think you need to have that opportunity to do that. I think 3 months is a reasonable time frame, given that you've already had a head start on it. It addresses Mr. Cleaborn's client's concerns that he expressed, I guess, in terms of let's keep this moving along, which I completely agree with. So I think it's a reasonable time frame that isn't going to result in an undue delay at this stage. I don't think it's appropriate at this point to set some kind of drop dead date for the filing of the returns, Mr. Finling, as you suggested. Number one, because I think over the next couple of months, it's likely that even if I set that date today, one or more of the parties is going to be filing some kind of motion to push that out based on what they learn or based on the status of their discussions or negotiations. So I don't want to set a date today that I'm fairly confident, if it's a 90-day kind of time frame, I'm going to end up with some kind of request to move that date anyway. And because what I see this as, based on what you've all said here, is resulting in one of two different outcomes. Either number one, the parties are all able to reach an agreement in terms of whether or not they're deductible, and Mr. Mueller becomes comfortable with that, and Mr. Finling files the returns along with Mr. Mueller, or some other arrangement is agreed upon where someone else files the returns. Either way, option one or outcome one is some type of agreement amongst all of you about how to get this going forward. The other option I see is the court making a determination based on a motion from Mr. Finling that either he does or doesn't have the authority to file those returns. I don't see the court as being in a position to make a decision or include in such an order that the return must be filed with that income as deductible or not deductible. In other words, I don't think the court, and of course the parties will be free to brief this, but I don't think the court has the jurisdiction to make a determination about the applicability of a deduction under the federal tax code in the context of this receivership action. I think what my authority is going to be limited to is either giving Mr. Finling the authority to file that return however it gets filed, or not file it. And I think the other parties may have good and strong arguments for persuading the court why I shouldn't order him to file it based on those kind of considerations. But I think in terms of the court making its decision based on the ultimate deductibility of those payments, I don't think I'm going to have the jurisdiction to do that. So again, I see this resulting in one of those two ways. I think it's appropriate to give the parties the 90 days to attempt to reach some type of agreement. If we come back in 90 days and you're all fairly confident that's not going to happen, then I'll set a timeline for Mr. Finling filing his motions. That way, you're not all working on the motion part of this, if that eventually happens, and trying to come to an agreement. Let's spend the 90 days focusing on whether or not some agreement can be reached. If not, then we'll set a timeline for the filing of a motion, and then everybody can concentrate on their arguments related to that. So I say all of that to say that I will do a status conference order indicating that we'll set this for another hearing in about 90 days. Does anybody have any objection to doing that by Zoom as we're doing today?
No, Your Honor.
Okay. All right, and then when we're back again, if there isn't any agreement reached or the parties express that they don't anticipate an agreement will be reached, then I'll set a timeline for motions related to the filing of the returns, and we'll get it decided. Mr. Finling, anything else that you wanted to add today? Mr. Scheer?
Nothing further, Your Honor. Thank you.
Okay, Mr. Smith? Mr. Cleburne?
Nope, nothing further on my end.
Okay, Mr. Nelson?
Nothing further.
Okay, all right, thank you. That's all for today, and all parties are free to disconnect at this time.
Thank you very much. Have a good one.
Thank you. That also concludes the court's morning docket. The court will be in recess until 1:30.